Hello and good day. My name is Aljarmi El Misai, studied in Master in Information Technology at Solo State College. This video is all about the Republic Act 4200 entitled An Act to Prohibit and Penalize Wiretapping and other related violations of the privacy of communication and for other purposes. GR number 168338, February 15, 2008. Francisco Chavez, petitioner versus Raul M. Gonzales in his capacity as the Secretary of the Department of Justice and National Telecommunication Commission or NTC respondents. So, I am going to answer the 5 questions. The first question is, what is the case all about? So, the case is all about the allegation of conversation between former President of the Philippines, Gloria Macapagal Arroyo, and the higher-ranking officials in the Commission on Elections, or COMELEC. The case started from the event of national and local elections that occurred back in the 2004. The second question is, what are the facts of the case? The facts of the case were using the audio tape of the phone conversation between former President of the Philippines, Gloria Macapagal Arroyo, and the higher-ranking officials in the Commission on Elections, or COMELEC. This conversation is releasing through wiretapping. According to the Malacanang press conference, there are 2 versions of the tape. First one is complete version, supposedly, and the other one is about spliced, doctored, and altered version. Seems like Secretary Bonye confirmed that the voice came from the former President of the Philippines, Gloria Macapagal Arroyo. The third question is, what are the issues on the case? So, the issues on the case are the audio tape dissemination, which is beneficial to society's understanding of the challenges democratization faces around the world. This issue is considered as illegal. The fourth question is, what is the ruling of the Supreme Court? So, the ruling of the Supreme Court is that petitioner Chavez filed a petition under Rule 65 of the Rules of Court against respondents Secretary Gonzales and the NTC, praying for the issuance of the writs of certiorari and prohibition as extraordinary legal remedies to annul void proceedings and to prevent the unlawful, unconstitutional, and oppressive exercise of the authority by the respondents, alleging that the acts of the respondents are violations of the freedom of speech, freedom of expression, and of the press, and the right of the people to information on matters of public concern, and petitioner specifically as the court or the nullification of acts, issuance, and orders of respondents to commit or made since June 6, 2005 until the present, that quarter of the public rights to freedom of expression and of the press, and to information on matters of public concern, specifically in relation to information regarding the controversial taped conversion of President Arroyo and for the prohibition of the further commissioner. of such acts and making such issuance and orders by respondents. So, no law shall be passed abridging the freedom of speech, freedom of expression, and of the press, or the right of people peaceable to assemble and petition the government for the address of grievances. So, the last question is, what are your takeaways or learning on this case? One of the takeaways I learned from this case is the fact that extends protection of the freedom of speech, freedom of expression, and of the press to nearly all of forms of communication. It protects speech, print, and assembly regarding secular as well as political causes, and is not confined to any particular field of human interest. The protection covers myriad matters of public interest or concern, embracing all issues about which information is needed or appropriate, so as to enable members of society to cope with the exigencies of their period. The constitutional protection assures the broadest possible exercise of free speech and free press for religious, political, economic, scientific, news, and or informational ends. It is not limited to the exposition of ideas. The protection afforded free speech extends to speech or publications that are entertaining as well as instructive or informative. So that's all my answers in the Republic Act for 200 Chavez versus Gonzales GR number 168338 February 15, 2008. Thank you for listening my videos and God bless you. Bye.